What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
Welcome to Privacy Mavens, an exciting new podcast series showcasing brilliant women who lead in privacy practice. A maven is defined as one who is deeply experienced or knowledgeable, an expert. In this podcast series, you'll get to know trailblazing women privacy lawyers while also learning about hot topics in data privacy law. My name is Erika Douglas. I'm an assistant professor of law at Temple University in Philadelphia, and I'm your host for today. On this episode of Privacy Mavens, we're featuring Mary Ellen Callahan as our guest. Mary Ellen is an assistant general counsel for privacy at the Walt Disney Company in Burbank, California, where she acts as the lead privacy attorney on cybersecurity and privacy matters, including COVID-related issues. Prior to that role, Mary Ellen was in private practice and Chief Privacy Officer at the Department of Homeland Security. Mary Ellen's an internationally recognized leader in privacy practice and has received accolades for her outstanding accomplishments and creativity in privacy law. In our podcast today, Mary Ellen shares her insights on the impact of COVID-19 on in-house privacy practice and reflects on her career path to becoming a top privacy expert. Our discussion will include Mary Ellen's unique perspective on managing privacy in productions and procurement at Disney. So Privacy Mavens is brought to you by the ABA Antitrust Section's Privacy and Information Security Committee, along with Women.Connected. Welcome, Mary Ellen, and thank you so much for joining us today. I want to kick off by asking something so our listeners can get to know you a little bit better. What are you most looking forward to as this summer as we exit the COVID-19 pandemic?
Well, thank you, Erika. And I will say, after a very long year and a half, I am looking forward to going on my first official vacation next week to go to Yosemite and Sequoia National Parks. And I'm actually going to be traveling with two of my nieces. My 21-year-old niece has been living with me since February. She decided that Zoom school was not for her. And so she took a gap semester living with me in Los Angeles, working at a COVID vaccine site, helping to vaccinate Los Angeles County. And so she is wrapping up her time in Los Angeles, and she is together with her niece, her cousin who just graduated from veterinary school. We're going to go to Yosemite, and I cannot wait. And I'm really looking forward to it. And it kind of is a great coda to a very long year and a half.
Sounds like a wonderful end of the pandemic mark. So let's start with a bit of background on your career, then let's delve into the substance of our discussion of how in-house privacy practice has evolved during the pandemic. So a maven is a top expert, someone who understands and excels, and you've been a leader not only in privacy practice at top firms, but also at the Department of Homeland Security and now also in-house. So tell us a bit about how you came to be a privacy lawyer and some of the highlights of your career that have led you to this point where you have received this very Maven-worthy designation.
Well, I really actually happened into privacy. It was one of those ways that life happens, unique opportunities, and it happens with all of our careers, right? We don't anticipate that we're going to do something. We think we have our lives planned out for us when we're graduating from law school and nothing goes exactly as planned. When I graduated in 1997, privacy wasn't even a discipline. Privacy wasn't even an area. It was actually somewhat controversial to think of privacy as being a consumer protection issue. Former Federal Trade Commissioner Christine Burney had proposed this in the mid-90s, and it was still not getting traction necessarily. Christine then rejoined Hogan and Hartson, which is where I was an associate. And we met working on another project. And she said, "Hey, you're great. How about you come work with me?" And I said, No, I want to be a litigator. I'm going to be a litigator. That's what I'm going to do. And then I litigated some more and it wasn't going great. And I saw her again and she said, "How's it going? Why don't you come work with me now?" And I said, "Yeah, actually, that sounds like a great idea." And so she was just starting. We were working on all sorts of both competition, antitrust issues. Her client at the time was Netscape in the US versus Microsoft, antitrust litigation. And I started working with her and also working on ad serving technology and third-party ad servers in 1999. And it was one of those things where I liked working with her. I liked working with her clients. I decided that I didn't like litigation. I didn't like the adversarial aspect of it, or the denouement, where you have to get to the trial and working on the posturing and the positioning. I really liked working ex ante, ahead of the time, with people and trying to help develop what is now known as privacy by design. But at the time, I don't even think we had that as a concept. And so I worked with her and with others at Hogan and Hartson on privacy, on consumer protection, and also on antitrust issues until I became a partner in 2005. And when I became a partner, I looked around in the antitrust and consumer protection group, which is what it was known at the time, and decided that I'm not that great at antitrust. I don't really like it. I enjoy the privacy and consumer protection piece. And if people are going to do antitrust, they're going to go to Christine Varney or Janet McDavid or Sheris Posen, all of whom are renowned antitrust folks. And so I went all in on privacy. I decided that's where my practice was going to go. And given that the data breach notification laws had started in 2003, CAN-SPAM was 2002, and we really had a explosion of privacy and consumer protection issues. It was, I guess, a pretty smart bet on my part, but it wasn't a foregone conclusion when I made that choice.
Absolutely. I think privacy looks like a safe bet now, much, much more so than it would have been when it was beginning in the 90s. So as you look back on your career, I think of late, there's been this sort of renewed focus on grit and resiliency and how important it can be in our careers and our lives. Was there a moment in your career where resiliency has played an important role for you?
Well, I think that all of us have to figure out what we want, right? And I think that candidly, the pandemic has really emphasized that of what do we want in life? What do we want in our careers? What do we want personally and professionally? And resiliency has to be a part of it and has to be a factor within it. But it also, we don't have to go and say we're going to take everything on the chin and we're going to be, some sort of stoic Victorian model of not responding. When I was at Homeland Security, it was one of the best experiences of my life, but it was also a really hard experience in my life. And when we talk about the Chief Privacy Officer at DHS, it is the first statutorily created privacy role. It was created in 2002. So think about the timing when they created the department itself. And it's the equivalent of an assistant secretary. So that's great. I got my own budget of $8 million. I had an extraordinary team that I built up to be 45 direct reports, all great work. But at the same time, you had to both be integrated. You had to do privacy by design at DHS. And I think we might talk a little bit more about that later. But you also had to be objective and to stand back. And I think that privacy has some tension built into it naturally, that you have to know what's going on with your clients. You have to know what's going on in the organization, whether it be a company, a law firm, or the third largest department in the United States, executive branch. With that said, that's what's so great about privacy, I think, is that you've got that objectivity while also the integration. One kind of example of a way that I think that it was fun to be the Chief Privacy Officer of DHS was I got to investigate the Inspector General. The Department of Homeland Security Inspector General, of course, consistent with the Inspector General Act, has its own authorities and is independent. But with that said, one of their vendors who was doing financial transactions had a data breach, and they had a thumb drive that wasn't authorized that they stored all of their financial data on. Thumb drives had been prohibited in 2005. And yet the Inspector General's own contractor was using it, lost the thumb drive, and had, a relatively big, but also sensitive data breach. And so the deal we struck with the Inspector General was he could do the investigation itself and tell me what the facts were. And then I analyze it from a privacy perspective. And I thought that was a good way for both of us to recognize our objectivity and our independence, but also to go and say, you messed up here, Inspector General, and to try to get them consistent with the privacy principles for the rest of the department.
Fantastic. So let's turn to the hot topic of this episode, since we're getting close to it anyways, how COVID has affected in-house privacy practice. I think we can all agree that everyone has experienced change in their work as a result of the pandemic. Privacy law has come to the forefront of the practice of so many attorneys, from health privacy to employee privacy and beyond. And it's particularly true in California, where you are practicing, where, of course, there's unique sort of state level privacy laws like the California Privacy Rights Act. So I understand that COVID has impacted the production of Disney programming and procurement. Can you tell us a little bit of the inside scoop of how your work at Disney has changed as a result of COVID?
Sure. I will say, just a caveat, right? I am a lawyer. I'm not going to give you inside scoop. I'm going to be able to give you stuff that is in the public domain. And I'm, of course, speaking, I guess, as a privacy maven, not as a Disney attorney. With that said, I really do think there's some great lessons from COVID, and particularly kind of the privacy piece. As we all went to work from home, the tracking, the monitoring, the what are we doing and what are we not doing with data and with elements, I think really initially really helped with working with my information security clients in terms of how do we structure this kind of work from home environment in a privacy protective way. But what was unique, and again, I'm not trying to speak out of school, but what was unique was we had to think about how to recast, for example, productions as they went to go stand up again, working with a lot of unions. And there are a lot of news stories about all of the different unions that were involved with the return to work for productions of what would work, what would not work, how do you negotiate these types of agreements? And again, how do you do data minimization when you're talking about a health pandemic and trying to keep people safe and secure? How do you have this kind of lowest common denominator of data collection, but also in terms of operations and who should we be testing when, and how should we be monitoring folks, and who are the health and safety managers in all of these different types of productions? And does it matter from, you mentioned California, but, Marvel has a big operation in Georgia. Does that change anything? What about internationally and trying to liaise with that? So what's been really fun for me and during the pandemic is that I got to meet a whole different set of people who I didn't know existed before. The people who worked on the productions, the people who worked on the employment issues, the how do you procure testing facilities, for example? How do you go and leverage this to make sure that we can do all this stuff? Are there privacy considerations? And what's been interesting to me is, obviously my team had relationships with lots of those different types of folks, but we moved from being secondary to primary in a lot of ways. And so it's been fun to see the shift. It's been fun to see how we can collaborate in different ways, whether we're, talking about testing or talking about, running any sort of program to figure out how to most effectively operate in this pandemic world. And so it's really been both interesting and novel to try to figure out what is the role of privacy in this world, and how do we do a data minimization, purpose limitation type of implementation to try to get, our businesses back up and running.
So on that note, did your experience with data privacy issues during the pandemic lead to any takeaways that sort of remain valuable as we transition back to a new normal practice?
Yeah, one of the things that I've been thinking a lot about is kind of the ubiquity of data and the always online, always available type of information. And certainly during the pandemic, when we were working from home, that issue was noticed. But in the Internet of Things, in terms of thinking about collection, and this is me as a privacy professional, not as an in-house lawyer, But, does that change the dynamic? Are there ways that we can continue to have privacy protections, have privacy by design, and not burden the individual consumer on all of the choices and all of the discrete notices and all the discrete aspects? And I don't have an answer for that yet. And candidly, I think it's got to be, both a technology as well as a policy solution. But certainly the vast majority and the collection of data is, it's a lot right now, and it's only going to grow as things increase.
Absolutely. So a lot of people in our audience are private practitioners. So any thoughts for them on how outside counsel can best support their in-house clients in this world of sort of COVID cognizant privacy practice?
Yeah, I will say I love being outside counsel. I loved being a partner both at Hogan and then at Jenner and Block. And I really love my clients. I had a great rapport with them and a great relationship with them. And I thought it was a really good outside counsel. What I realized going in-house was that as an outside counsel, you're always going to be one step or two step removed from what's really happening within the organization. And I kind of knew that to compare it to my Department of Homeland Security days, but you really get a sense of working on issues, day in and day out, and making sure that you follow the life cycle of not just the data, but of the projects, of the initiatives, and where we're going. So for outside counsel, I would say try to understand your clients. Try to understand their motivations, their incentives. One of the things I try to find, creative, thoughtful outside counsel who aren't just going to give me the black letter law. I get that. I can read that. But instead, what does that mean? How do we implement that? What are others doing? I don't need names, but I want to understand kind of what's our risk profile and where do things fall. So and trying to find that ability to say, black letter law is this. Here's a conservative approach of how to address it. Here's what a lot of people are doing, which is a medium approach. And here's a pretty aggressive approach, but it's defensible. And here are what the risks associated with that. If you can give that type of advice, particularly in privacy, which is such an evolving field and is so dynamic, I think that can really help your clients and can help you be a better steward to your clients as outside counsel.
So Mary Ellen, we could easily fill an hour or more chatting about your unique career achievements, but since we only have 20 minutes, I want to make sure that we get to talk a little bit more about something you mentioned at the outset in your role as Chief Privacy Officer at the Department of Homeland Security. You mentioned there's sort of a natural tension between privacy and knowing what's going on within DHS. And I think even from an outsider perspective, it sometimes seems like national security, to simplify, is sort of the opposite of privacy. So can you help us understand how those areas of law and practice were reconciled when you were in that role at DHS?
I do think it was very thoughtful of the U.S. Congress to go and embed a privacy officer into DHS. And I think it was exactly the right call. It was 23 different agencies coming together, 300 or 240,000 people, and by far the most interactions with the public that any other agency has, whether it be at the border, at the airport, for immigration applications, you name it, we're touching a lot of data. And the way I tried to talk about privacy in Homeland Security is to say, I've always flinched at the statement about balancing privacy and security, and never was that more obvious than at Homeland Security. Because if you take, to your point, Erika, if you take this big, scary thing of national security and what does that mean? And it's so ominous. And then you put it on a scale with this ephemeral, somewhat subjective concept of privacy, the weight is going to be disproportionate. You're going to disproportionately value the national security interests. And that's not what we should be doing. And that's not why the Chief Privacy Officer was created as a unique entity. And so what I tried to talk to Secretary Napolitano and Deputy Secretary Lute about was integration. It is by far, it is the definition of privacy by design, right? That you have to be integrated early. You have to be part of the process in order to really be able to evaluate the privacy risks, but also to try to have some mitigations into the approach and into the process. And one of the ways they did that at DHS was the Deputy Secretary instructed all the components, and that's TSA and Customs and Border Protection and Immigration and Customs Enforcement, to have a senior level privacy officer who reported to the head of each of the components. And that person didn't report to me. It was a different relationship, right? They were embedded in the team. They were the ones who were going to identify the issues. They were the canaries in the coal mine, so to speak. And they were the ones who were developing the program. With that said, based on my statutory authority, I was able to approve it and to review it and to have a little distance from the program itself. And so you had this embedded environment where the officers could really work with the components, but you could also have an objective person step back and say, is this consistent with what we've done in other components? Does this make sense? Should we have other checks and other balances? And then the final point in terms of how do you think about the privacy officer in Homeland Security and in other agencies is to go and check, right? So privacy impact assessments were required, system of record notices were required. But I also started to institute reviews, periodic reviews on major initiatives to go and say, do these controls still make sense? Are the privacy protections still being kept? And are there other things we should think about, consider, or maybe reevaluate as these things went on? And that way it really helps with the privacy by design and with the life cycle of data. It's not perfect, but I got to say, I think it was very effective at Homeland Security.
I want to turn to our final topic as we come to the end of our time together here. We have a lot of young attorneys listening to you who would certainly love to sit in your shoes as a privacy maven someday. So what is your top piece of parting advice for young attorneys or law students who are interested in privacy practice?
Absolutely. I've got to say, privacy has been such a dynamic and interesting field, and I really was lucky to fall into it. But I was also lucky to be working with some really great mentors. And my key to you is to say, look at the type of work you like to do, look at the type of person you like to work with. I mentioned that I was supposed to be a litigator when I started, and I realized I didn't like that environment. I didn't like that dynamic. And you may like the practice of privacy, but you may go and say, you know what, I want that adversarial relationship. Okay, well, then maybe I'll look at privacy litigation, or maybe I'll look at some other enforcement. Like, think about the skill sets that you like. Think about how you like to interact with people, what type of work you want to do. The profession, the legal profession writ large is hard. And so what you want to do is leverage your own skills and what you like to do and find people who you like to work with. I actually have been very blessed to be mentored by a whole host of great women. I've mentioned several of them from Hogan already. Obviously, Janet Napolitano and Jane Lute when I was at Homeland Security, Dorothy Atwood here at the Walt Disney Company. And that's been a wonderful and perhaps unexpected opportunity for me. But I also look for those type of women who can teach me and who I can learn from and who I can leverage their unique skill sets. So I would say, look for the helpers is always a phrase, but look for the mentors and see what your own personal development is. One thing I do, Erika, is every year or 18 months, I go and say, okay, let's assess where I am. What's happening? Am I still happy? What are the skills that I want to get out of the next year? And just kind of do a pause and reevaluate where things are. And I've done that since I was a young associate. When I went to Hogan, I thought I'd be there 2 years and then maybe join the government. And I was there 12 and a half until I went to Homeland Security. But I did that kind of pause and reflection every year or so to make sure, are we still online? Does this still make sense? And I think that that's a really healthy thing for all of us to do in our professional and personal lives.
Absolutely. I think that's wonderful advice, particularly as we come to the end of the pandemic. Let's redo that one. So thank you. I think that's wonderful advice, Mary Ellen, particularly as we come to the end of the pandemic. And so I want to thank you so much for joining us, for all of the wonderful contributions you've made as a Privacy Maven, and also for all of the thoughtful contributions in our chat today. And I want to encourage our audience to join us next time to learn and get to know our next leading privacy expert on the 3rd episode of Privacy Mavens. Thanks, everyone.
We hope you enjoyed this episode of Trust in Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.